He's also an educator, and he's deeply committed to raising the level of professionalism within our industry. And courses like this are those opportunities to raise that bar. So we're so glad to see all of you here with this, and we're so glad to have Trent with us. Good morning, Trent.
Good morning, Matt. Good morning. How are you?
Great. And we're happy to see you with a sweater, not in Florida.
I will be in 2 weeks. Yes, I will have a sweater in 2 weeks. Uh, I'm going to Florida for the winter. Good morning, everyone. Good morning. 46 folks. Just can you all give me some idea, just hands or something? How many of you are relatively new agents? Only been in the business maybe, let's say, a couple of years or less. Just give me an idea. All right. How many of you been in business more than 10 years? More than 20 years?
Hey, Trent,
Yes.
I think we need to see some faces. Put
I would
yourself
like
on
to
the
see
camera.
faces.
We're okay. You don't need to have hair, makeup, and lights. It's all good. We're amongst friends here. Look at this mug. Come on. I don't have much to work with here.
Yeah, it's always nicer to see people. See, because I'm looking on the big screen TV because I can't see you on my this little computer. So thank you for turning it on. It just makes it better. Now, one of the things that we'll do, if you have questions, comments, interrupt me, ask questions as we go along. We don't, this is interactive. You don't have to wait till the end. Some of you, and ask, about experienced agents, because some experienced agents in here may have something they can offer. We're all here to learn from one another. I always believe that I don't care how long you've been in this business, you should always be open to learning. So I always learn something myself every time I teach. So so don't feel like you can interrupt or ask questions or comments at any point. First thing I want to start with, we're talking about the buyer agency contract today. We're going to go through every paragraph. We know there is a buyer agency contract, and all these documents are in Matt, they're all in where chat. Where are these documents? Where they can. All right.
Just
So we
drop
have.
the link in there, Trent. The link to all the docs is there right now. So check it out.
All right. So one of the things, so we want to go with the buyer agency contract is really the exclusive buyer agency contract. I always never could figure out why they don't call it the exclusive buyer agency contract, because that's what it is. There's a buyer agency contract that we're going to really deal with today. But there's also a non-exclusive buyer agency contract, and we'll talk a little bit about that and what the differences are. But first, let's start with anytime you meet with anyone who you have a substantive conversation about real estate, what document did you have to give to them? Anyone, just tell me.
Consumer notice.
Consumer notice. Consumer notice just describes, and we have that in the chat also. Just lays out for the consumer all the different business relationship choices that you can have with that agent. How long do you have to keep the signed copy of the consumer notice once, if there's no transaction occurs? If no transaction occurs, someone comes to your office tomorrow, you show them a property, you give them a consumer notice, you show them a property, they never come back. How long do you have to keep a consumer notice? If no transaction occurs? Anybody know? 6 months. You, the agent, I'm sure your broker's not going to do it. You need to keep a copy of this consumer notice. You need to show proof that you gave that consumer a consumer notice, and you need to keep this for at least 6 months. So when you do meet with clients, and there's also, if they call you on the telephone, there's also in the chat, there's an oral consumer notice that you just have to read verbatim. But keep a copy of the consumer notice for at least 6 months. If a transaction occurs, then it would be put in a file, and your broker has to keep that file for at least 3 years. So just keep that in mind, because a lot of agents forget that they have to keep this consumer notice for those 6 months. Any questions or comments about that? Otherwise, then let's get to the contract. Let's look at the exclusive or the buyer agency agreement. If you are, and I call these employment contracts, the listing contract, the buyer agency contract. You're being hired. In this case, you're being hired by the buyer to help that buyer find a property. A listing contract, you're being hired by the seller to help that seller sell his or her property. So these are employment contracts. We should understand what's in these contracts. If we're practicing real estate, we should know, because it makes a difference. Because I've been around a long time, and there have been many times where agents would say something, especially as relates to the consumer notice, I mean, not consumer notice, agreement to sell, and they're just completely wrong. And it's like, well, where is that? If you don't know, then they can take advantage of your lack of knowledge. Because if they said, and I'll give you an example, I remember years ago, an agent said to me, my buyer was trying to get the pre-approval. We were running into all kinds of issues. The commitment date passed. The agent called me and said, Trent, and my client had put down $10,000. And she said, well, if you don't have the commitment by tomorrow, because today was the deadline, if you don't have it tomorrow, my client's going to just keep your $10,000. And if I didn't know better, I would maybe panicking and saying, "Oh my goodness, please, we don't want that. We'll try to get this commitment." But the agreement sale says that you can't do that. If the buyer does not get that commitment on before the date that is in the contract, the seller can terminate the contract. But it also says that the buyer is entitled to have his or her earnest money deposit returned. And this was an experienced agent telling me that. And when I showed that to her in the contract, she didn't even know that was there. So I say this to say, if you know what's in these contracts, then you're probably going to be better. I'm not going to say this, than a lot of agents out there. That's why I think this stuff is important. If this is what you do for a living, we are professionals, we're real estate professionals. We ought to take the time to know what's in these contracts. When you're not busy, take one of these contracts, read through it, read a page a day, and just find out. You'll be enlightened, and I definitely believe you become a better agent. Anybody agree with that? Can I get an amen from someone? No one agrees with me?
Amen. Amen.
Amen.
All right, I was gonna say, boy, I'm gonna have to go back to work. Nobody agrees with what I just said. Maybe I'm in the wrong place. Maybe this is an intro to something else. But all right, let's look at the buyer agency contract. Let's start at the first, the broker. The broker obviously is the name of the company, not the name, not the broker of record, but the name of your company. And make sure when you fill this in, it's the name of the company as it appears on your license. Not, you don't put just Remax. If you're the Remax Mainline, it would be Remax Mainline, whatever the name of your company is. These are contracts, and we want to make sure that the names are spelled correctly. That's my pet peeve. And make sure they're the full name. So the name of the company, the license number, the address, all the information about the brokerage. On the left side, on the right side, your information, your license number, your cell number, email, et cetera, et cetera. If you're working with another co-agent, then you should put both agents' information on this form. If there are two of you working with that client, put the information on also. All right, the buyer, obviously the buyer's name, all buyers' names. If there's two of them, put both and put full names. Obviously, you wouldn't put Bob Smith, you'll put Robert Smith. If they have middle initials, if they're juniors or the second, I think these are contracts. You should fill it out as completely and as accurately as you possibly can. Buyer's mailing address, obviously, you will get this information from the buyer, phone number, email, fax number, etc. Now let's get down to some interesting points. Buyer understands, paragraph on line 13. Buyer understands that this buyer agency contract is between the broker and the buyer. Unfortunately, some newer agents don't understand that. That's why it's probably, I know it's there because the licensing law requires it to be there, but you need to understand that these contracts are between the company, whatever the brokerage is, and the client, in this case, the buyer. So if you quit, unless your broker allows you to take this contract with him or her, with you, then fine. But these contracts are between the company, the brokerage, and the buyer. Or if it was a listing contract between the company, the brokerage, and the seller, you just represent the brokerage. But these contracts, it may be your mother's property, but just because you quit that brokerage and go to another, you're not entitled to take this client with you unless the broker allows. All right. Does a buyer have a buyer agency contract with another broker? Yes or no? Well, if you have yes, if they answer that question yes, you need to stop because there could be an issue there. Clearly, we want no because this is an exclusive right to sell. Exclusive buyer agency contract, which means that buyer should not enter into any other contract until this one expires. So if the buyer says, yes, I have another exclusive, if I have another buyer agency contract, you need to find out why. Now, they could have a non-exclusive buyer agency contract, and that's fine, because what's the difference between a well, let me get out. So they could, but if you have a yes there, you need to stop and figure out why. And if it's more complicated, you may have to talk to your broker, but it should be no. All right. Because if it is yes, let's say the buyer did sign an exclusive buyer agency contract with another office, and then they sign it with you, which they shouldn't. But if they do, then they may have to pay 2 commissions. Because one thing that, well, let's just say this: the difference between a buyer agency, the exclusive buyer agency contract, and a non-exclusive is what? If you have an exclusive buyer agency contract, during the term of this contract, no matter who finds that property, the broker is entitled to a commission. In a non-exclusive buyer agency contract, the broker only is entitled to commission if that broker had his or her hand. Well, let me read from since we're talking about it, go down to 1B, paragraph 1B. This is and I'll read from the non-exclusive. This is exclusive buyer agency on paragraph 1B. It says this contract applies to any, and there's a key word, any property that the buyer chooses to purchase during the term of this contract. Buyer will not enter into a buyer agency contract with another broker / licensee that begins before the ending date of this contract. So no matter what, if this buyer buys a property before this contract expires, the broker has earned the commission, no matter who introduces that buyer to the property. Now, look at the non-exclusive buyer agency. Paragraph 1 says this agreement applies to properties introduced or shown to the buyer by the broker, or to any property that the buyer chooses to buy as a result of the broker's efforts. Buyer is not obligated to a term, nor are the broker and the buyer obligated to work with each other. This contract starts when signed, blah, blah. So exclusive, which we're focusing on today, an exclusive buyer agency, one, no matter who finds that buyer a property, the broker earns a commission. A non-exclusive, if the broker had nothing to do with finding that property for that buyer, then that broker does not earn a commission. The broker only earns a commission if that broker has something to do with this property, with helping this person to secure this and close on this property. There are a lot of people, probably a lot of people in our industry use the exclusive buyer agency contract. But I can tell you, an investor probably does not want an exclusive buyer agency because for instance, if you're an investor, you're not loyal to the agent, you're loyal to the property. You're trying to find multiple properties. So you probably wouldn't end up signing an exclusive buyer agency contract. An investor is probably going to want you to sign a non-exclusive because you earn a commission on any property that you introduce to that investor. But another agent at another office may introduce them to a different property that they also purchased. So they are more likely to enter into a non-exclusive buyer agency contract with you if they're an investor. At least, can someone say something? Does anybody agree with what I've said so far? Anyone have an experience? Anyone have a comment? All right.
I agree with you, Trent. Good morning.
Good morning. All right. Thank you. Can I get 2? I heard 1. Can I have 1 more?
Yes, I agree.
Right.
Yes,
Right.
agreed.
Can I get 6? I heard 6. Can I get 7? Go on. All right. Go back to the buyer.
Sure, I agree.
All right. Well, good. We're up to about 12. How many people we have? 53. All right. That's good. 7 out of 53 ain't bad. All right. Go back to the exclusive buyer agency contract. So let's look at the paragraph 1. It says, go down to, it says, even though the broker's fee or portion of it may be paid by the seller or the listing broker will continue to represent the interests of the buyer. One thing we all know, if we've been in this business, it does not matter the source of compensation. The source of compensation does not determine agency. It does not matter who is paying your commission. You have a contract with the buyer, and your loyalties or your fiduciary responsibilities are to this buyer. It doesn't matter that the seller may be the commission may originate from the seller. it does not matter. Whoever you sign a contract with is a person you are loyal to. All right. B, it says this contract, and we just read that. That's what makes this an exclusive buyer agency as compared to a non-exclusive buyer agency. Again, 1B, this contract applies to any property. So if that buyer buys 4 properties before, well, no, that's not true. Let's read this. So let's go to the next one. This contract applies to any property the buyer chooses to purchase during the term of this contract. Buyer will not enter into another agency contract with another broker that begins before the end date. Let me ask a question. Let's say you have this exclusive buyer agency contract and it ends, let's say January 31st of 2024. Your closing is January 1st. And then the buyer buys another property January 10th. Would you be entitled to a commission if they sign an exclusive buyer agency contract? Let me say that again.
Yes.
Your contract ends January, I'm writing it down myself, January 31st, 2024. You close on a property that you showed to this buyer January 10th, let's say. You close January 10th. On January 20th, this buyer finds a property on his and her own and closes it. Would you be entitled to a commission if you sign this contract?
Yes.
They say, okay. Most people think yes. All right, go down to paragraph 1C, where it says if buyer is negotiating or has entered into an agreement to sell, this contract ends upon settlement. So the answer would be no. Once you close, if I introduce you to a property and we close on that property, this contract, this buyer agency contract ends. So anything that buyer buys afterwards, you would not be entitled to a commission. All right. Any questions about that? Go back to the end date. Go back to B. Make sure the starting date, the contract starts when you sign it, unless you put a different date. You may not want to start until January 1st, but if you leave that blank, it will start the day that the last person signs it. Once this contract has been fully executed. When is it fully executed? When the last person signs, which is no. Let me say this: it's probably better to have the buyer sign it before you, the agent, sign it. Why? Because let's say the buyer doesn't date it, sends it back to you. If you sign it first, send it to the buyer, buyer sends it back to you, but doesn't date it, you don't know the execution date of this contract. You don't know when it starts. I mean, it starts when you get it, but if you have any issue as to when this contract started or what the execution date or when it ends, because let's say you put in this contract is good for 30 days. But the buyer sends it back to you today, but the buyer said, well, I signed this 4 days ago. So what's the execution date and when does this contract end? It's always better to have the buyer sign it. And then when you sign it, now as the agent, you're the last person to sign it. So you know the execution date because the execution date would be the date that you signed it. It doesn't matter the date that the buyer signed it. Make sense? Just sign it, let the buyer, always let the client sign contracts first. Is the agent, you should be the last one because the last person who signs it, that's our execution date. That way you know what the date is and you know when this contract begins, you know the contract ends, you know when if it's an agreement sale, when inspections need to be done, et cetera, et cetera. All right. So also the contract.
Trent,
Yes.
we got a hand raised here. Drew's got his hand up. So
yes, sir.
Drew, unmute yourself, Drew.
The question is, I've had this problem actually twice in my career now, where buyers have moved on from me and purchased another property while still under contract with it here. What are the repercussions? How do you go about this, and how much of a headache in legal and whatnot would that be to force the hand of the buyer to cough up the commission?
Well, let me say, I'm not a lawyer, so I would say that you probably should talk to your broker or attorney. But what I would say, personally, I'm a broker. And I've been in this business a long time. That happens. What do? I personally would do nothing. But I'm not saying that's what you do. But I know buyers do that. That's why I bet you, let me ask you this. how many agents on this Zoom who are experienced agents don't even have these contracts signed until they find a property? Now, that's really not the right way to do it. But how many, somebody be honest with me and tell me if you say, okay, I see Marie saying, a lot of agents will not even have a buyer agency contract signed until the agreement. But here's the problem with that. The Real Estate License and Registration Act says that you can represent a buyer without the contract. But it also says that you can't be paid without a contract. So if you have a problem getting a buyer to sign the contract once you find an agreement, once you put together agreement sale, then you really aren't entitled to a commission. I would hope that would happen. It's always better. These newer agents, I know I've done this myself, but newer agents listening, get a buyer agency contract signed up front. But going back to the question of Drew, I think that's a broker question. Do you all want to go after that buyer or do you not? I personally would not myself. If one of my agents came to me with that, I would say just let it be. I'm not. I wouldn't do it. But that's just me. I'm not telling you how you should do it or how your broker does or what the policy in your office is. But I may choose not to.
Yeah, I got lucky on the first one where the brokers talked to each other and they did like a referral on it, which was.
And see that, and you know what? That's actually, Drew. That's actually good. I think that's a good way to resolve it. Have the broker call the other broker and say, "Hey, give us a referral fee." And if that happened to me and some broker called me, I would probably suggest something like that. All right, we don't want to have to take this any further. Let's let give me a referral fee. I think that was a good way. That's a good way of resolving it. So thank you, sir.
And not to hog up and much more time, but so what real good is this piece of paper if we can't kind of enforce? And
no, you can't enforce it. No, that's right. I didn't say you can't enforce it. I was saying I would not. I didn't say you should enforce it. Or you have to ask you should ask your broker whether to enforce it or what the policy in your office. I don't enforce it. I'm saying I can't speak for any other broker or any other office. I'm telling you what I would do. I don't want to spend the time, the energy, the money chasing a buyer who went to buy a property somewhere else. I'm too busy for that. I personally wouldn't do it, but that's a question up to your broker. And I do believe these contracts are absolutely important, and you could go after that person. And there are brokers who do it. I'm just telling you, I'm not one of those brokers who do it. Now, if the buyer was just flagrant and they were brazen about it, then maybe I would. If they just came by and said, ha 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 ha, I have a contract with you and I just bought $1 million property, you don't get a commission, ha ha. Then maybe I would go after it. But I would venture to say probably most people wouldn't. But don't think this is a useless contract, because it is not. It is an important contract, and you have the right to go after that person if they breach it. Whether your broker or you or anyone else chooses to do that, that's a decision that you would have to make, or your broker. All right, the ending date. Make sure you put an ending date in this contract. We're back on a 1B, ending date. If you leave this blank, you have an incomplete contract. This contract could be void, it may be unenforceable. You may have some issues without putting, when does this contract end? Is an open-ended contract. Whatever you do, make sure you put an end date. This contract we don't have open-ended contracts. Put an end date so you and the buyer both know when this contract ends. Do not, and I've seen buyer agency contracts that are blank, and then who decides the end date? Well, if I'm the buyer, I'm going to decide. Maybe I want to end today. So make sure you have an end date.
We got another question, Trent, from Mary Hogan.
Yes.
Unmute yourself, Mary, please.
Good morning, Mary.
Good morning, Trent. Thanks for taking my question. So yes, and what you're saying right now is actually my total question. Because I generally try to make sure I get a buyer agency signed initially when I meet with buyers, because I think it really helps formalize our relationship.
Exactly.
And have
I
the
agree.
buyer take this seriously and not,
Exactly.
the flake factor is big. So, the more I can nail it down, the better. But I wanted everyone's opinion on, on that end date. I always put is terminable within 24 hours written notice unless we are under contract or in negotiations, which I know it says that in C as well. But I guess I just find that makes it a little more palatable for these guys to sign the buyer's agency agreement, because sometimes people are bristly about the formality of this contract.
Right.
Now, with things changing with commissions, et cetera, potentially, I got to figure this out. So I want your opinion on that.
Well, let me just say this. My opinion is I've been a top selling agent for long years. I got a license 20, and when I was at Remax, every year I made the 100% club. So I sold a lot of properties in my life. I can tell you, I've always let a buyer out of a contract if they want it. My feeling is this: if you don't like me and you don't want to work with me, I will let you out of the contract. That has always been my personal policy. Now, again, I'm not telling another office how to do anything. I think that I don't like the idea of an agent being forced to work with me when they don't like me. So I will let you out. Like I said, I'm not letting you out if I know your cousin just got a license and your cousin wants to show you the property. So you want to get, no, if you really just we don't click and you really don't want to work with me, I would just say, all right, I'll let you out. I think however you do it, I think giving a buyer an opportunity to terminate this within 24 or 48 hours, I think that's smart. I've never ever enforced one. Again, I'm not telling anyone else. I'm telling you how I do it. I don't want to work with anyone who doesn't want to work with me. That's always been my philosophy. I've never had a problem with the buyer, leaving me, but we all have clients who we just don't want to work with. Otherwise, you could just use a non-exclusive buyer agency contract. That's what I would use, Mary. If instead of giving them instead of saying you can terminate this, why don't you just use a non-exclusive where if you introduce them to that property, they end up buying, you earn a commission. If you don't introduce them to that property, they can go anywhere and look and have other agents show on properties. You earn a commission if you're the procuring cause. So I would probably just sign a non-exclusive agency contract with these buyers than the exclusive, and giving them an opportunity to end it early. That makes sense, Mary. But again, it's up to you. I know. Well, I don't say that. I've never been. I've never had it happen. But if I've always said to a buyer, this is a contract. But if you're not happy with the way I do business, then I don't want you to work with me. I really don't, because I think I'm a pretty good agent. And I think so. If you don't think so, maybe I'm the wrong agent, right?
Yeah, I mean,
All right.
that's kind of how I couch it too. And I think putting that language in the end date sort of is communicating that as well, because I feel the same way.
Yeah,
I don't,
I would agree.
I just say to them, I'm like, look, we make, if it just turns out that maybe we aren't as much of a click as as a fit as we thought, no worries. But let's have the respect and decency with each other to just write a note, even if it's an email, just like send an I'd like to go in a different direction. No hard feelings, blah, 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 blah.
See, that's how I look at it, Mary. I look at it like if we're not clicking, it's okay for you to go back out. I'm okay with it. I'm okay. All right. Let's look at paragraph 2, broker's fee. Of course, as we all know about the new climate with the lawsuits and the settlements, and now lawsuits are popping up all over the place because sellers, we're going to run into some issues. We'll talk about this. We don't know if sellers are going to start not paying as much commission because for fear that we're going to share them with the buyer's agent. And so I don't know. I mean, every time I go to a listing contract these days, a listing appointment, I talk about my value. And whenever you're talking about commission, I've always, and you should do this in light of not of what's going on right now in our marketplace, but what is your value? What do you bring to the table? How am I going to get your property? So what am I going to offer you? I'm going to do open houses. I'm going to do these flyers, and I have all these. Tell them your value, and negotiate that commission. And one of the things that I always say was best, I have never said to a client, to a seller, I want this amount of commission so I can share it with the buyer's agent. I always say, this is commission that I want based on my value. And hey, as an incentive to find you a buyer, I'm going to share this commission with the buyer agent. But the commission you're paying me, I'm worthy of that commission. But so that I can sell your house faster, I'm going to share the commission. So I've never ever looked at it like the seller is paying the commission of the buyer. I always looked at it as that the commission, whatever commission I negotiate with the seller, is between me and the seller. If I want to share that's between me and the buyer agent. We never had to share commissions. I think MLS you could put up to what, $1, I think, or 1 penny. I don't know. You could now, I think you can now put 0. But I think when we need to understand our value as real estate professionals. And one of the things that you can show value is by knowing your contracts, right? And so, but I'm jumping ahead. Let's go to broker fee. So we know that no association of realtors has set or recommended a broker's fee, and buyers have negotiated. And this becomes more important now than ever, that no association of realtors, no one has told me what I should charge. This is my fee based on my value. This is the fee that my brokerage charges. I have not talked to any other brokerage. I don't know what they charge. This is my fee. This is my policy in my office. This is the fee I want based on the value that I bring to you. All right. So, and it says the broker and the buyer negotiate the fee that a broker will receive for exercising professional knowledge and skill in locating and assisting the buyer in the acquisition of real estate, which is available and suitable. So I think it becomes more important that we let people know what we will do, our value, because now buyers may have to be paying some of these commissions. All right. We'll talk about it in a minute. Well, let's talk about it now. Look at 2B, broker's fee paid by the buyer to the broker is as follows. Number one, in a purchase transaction. So now you really have to have a serious conversation with the buyer. It says, with a seller represented by a real estate broker, the fee is blank, a percentage of the purchase price, or blank, whichever is greater, and blank. So how will we fill that in? Let's say with a seller represented by a real estate broker, let's say the fee, I want 6% fee. I'll put 6% of the purchase price, or that second box is a flat fee. Maybe I want at least $10,000. So let's fill it in. So it would be in a purchase transaction with a seller represented by the real estate broker, the fee is 6% of the purchase price, or I'm just making up numbers, y'all, $10,000. And let's say my office charges every buyer of some type of conveyancing fee. Let's say $200. So now it could be with a seller represented by a real estate broker, the fee is 6% of the purchase price, or my flat fee of $10,000, whichever is greater, and $200. All right. So you get to decide how you're going to do this. But now be mindful that let's keep on and I'll come back up. A is when the seller is represented by a real estate agent. 1B is when the seller is not represented by real estate. That's a FSBO. So it's the same stuff. But the first one, if there's a real estate agent involved, this is what I'm looking for. The second one, 1B, if it's a for sale by owner, this is what I, as your agent, is expecting to get. If I get less than what I'm expecting, buyer, look at number 3. Well, let me drop to 3. It says, if the amount received from the listing broker is less than the amount in paragraph 2B in a purchase transaction, or the other one's a lease transaction, buyer will pay broker the difference unless the seller agrees to pay the difference as a term in the agreement of sale. So buyers need to understand that let's go back to my example. I'm saying, hey, buyer, I want 6% of a transaction or a flat fee of $10,000, and I'm charging you a $200 fee for whatever fee that may be that my office charges. Let's say that you get the house is 100,000, just say 100. So you wanted 6%. So that's 6,000, but you put a flat fee of 10,000. So it says whichever is greater. So you would get 10,000. But let's say that you're going to end up with 9,000. then that buyer would have to pay the difference unless you can negotiate with the seller to pay that $1,000. One of the things I think we're going to have to be careful with now, I haven't seen it happen yet, but I suspect that it's coming because the way they have put this lawsuit out and the way I hear it is that the sellers are being ripped off by real estate agents or realtors because they are making them pay the fee of the buyer's agent when the buyer's agent ought to be paying their own agent. Of course, I think that's nonsense, but we need to be careful here because if you're going to have the buyer, if you're going to show properties to a buyer and the seller is not offering any compensation, the buyer needs to understand that they have to pay, in our example, $10,000. I have spent most of my career working primarily with first-time home buyers. That was my niche because I love educating them. And it's their first experience. And I want to make it a really good one for them. And then they would be my repeat clients for years and years to come. Many of my clients wouldn't have $10,000 to pay my commission. They wouldn't have it. If my clients had to pay, if I look back over the hundreds and hundreds, I think I was involved in over 1,000 transactions in my career. I would venture to say that 75% of those buyers would not be able to buy the property if they had to pay my fee instead of the fee originating from the seller. So you have to make sure buyers understand that this is a fee that they have to pay if you, the agent, don't get, in our example, at least $10,000. Now that the agent may say, hey, I don't want you to show me properties where the listing agent is not sharing the commission. So that's the conversation we're going to have depending on what's going to happen. I haven't seen it yet, but we may start to see sellers saying, nope, I'm going to pay a certain amount to you. You want to give some to the buyer agent, that's fine, but I'm not paying anything more than this percentage. And maybe the listing agent is offering nothing to the buyer agent. So I think this becomes more important with what's going on in our industry today. Any questions or comments? All right, go back, look at 1B. When I said, I'm sorry, 2B2, where it says a broker's fee in the event of a lease transaction is blank. Many times agents leave that out because they say, I'm dealing with a residential sale, not a lease. Well, what if this property does not go through and the seller agrees to allow the buyer to rent it? Well, you may not be entitled to a fee. Put something in that blank. What do you want? If this is a lease transaction, do you want $3,000, $4,000, $5,000? You want 2 months rent? Whatever it is, put something there, even though this is not a lease transaction. But in the event, I've had at least 2 times when things didn't work out and my buyers end up renting the house. So it can happen. Don't leave that blank because then you may not be entitled to a commission if there's nothing there. Any questions or comments? All right, look at 2B3. It says, if the amount received from the listing broker is less than the amount, we just talked about that. Just remind buyers that if, using an example, 10,000, if I earn less than 10,000 from the seller of this property, then you have to make up the difference. Some buyers need to understand that they may have to come to the table with more money than they originally thought. Look at 4. Blank a broker's fee is earned and due at the signing of this buyer agency contract. If your office has a non-refundable fee that they charge, again, I don't know what office is charged because we don't talk about fees in other offices. We only talk about the fees that our office charges. If your office charges an upfront fee, then just make sure you put it there. But keep in mind that the upfront fee is part of your fee. It's not addition to. In other words, go back to our example. If you were helping to get 10,000 and you had an upfront fee of 1,000, then you would be entitled to 9,000, not the 10,000. You have to subtract the upfront fee from whatever fee you're entitled to. All right. Paragraph 2C, it says the balance of the broker's fee is earned if buyer enters into agreement of sale to the term of this contract. That's what makes it an exclusive buyer agency contract, whether brought by the broker, the broker's licensee, or by any person, including the buyer. If buyer defaults on the terms of this agreement, the broker's fee, blah, blah. Let's just say, so this is an exclusive right to sell. Does not matter who introduces that buyer to the property, who that buyer ultimately decides to purchase. You have earned your commission if during the term of this contract. D, if the buyer enters into an agreement of sale for a property after the ending date, this is just I guess is a broker protection. I mean, this is just saying that let's read it. If the buyer enters an agreement of sale for a property after the ending date of this contract, the buyer will pay the broker's fee if, one, the agreement of sale is a result of the broker's efforts during the term of this contract, or the property was seen during the term of this contract, and if the buyer is under an exclusive buyer agency with another broker the buyer is not under another exclusive buyer agency with another company. So if you are basically, you're the procuring cause. It was your chain of events that created this situation so that the buyer could ultimately buy this property. So even though the term this contract ended 2 days ago, but the buyer ends up buying a property that you introduced to them last week, you're still entitled to your commission. Dual agency, number 3. Are there any questions or comments? All right, dual agency.
I have a question.
Yes.
In this case, I've had a situation where an agent introduced a buyer to a property because I was out of the country at the time. It was a friend, and then the friend called me when I returned and said, I want to buy this property, but I had another agent show it to me. That agent, is that agent entitled to part of the commission? Or is that procuring cause?
Well, I think that's a question for Cheryl's or the professional. Cheryl, you want to say something about that?
So if there's an issue that you feel that you're owed a commission to, your broker would have to file for an arbitration, and it would go to our grievance committee, and it would be heard in an arbitration hearing. So it would be up to that hearing panel to decide.
Or could you just handle it with the broker and just give them a flat fee if you didn't want to go that route?
Yeah, you could. But if you wanted to go the route of, if the broker was not cooperative and you had to go to GPAR, Cheryl is the person to contact. She's the best.
John, do me a favor.
What was that? Oh. So yeah, it's always better for a broker to talk to another broker to resolve issues. And I know Cheryl will agree with that. It is always better. I mean, I've had brokers call me. I've called brokers. I said, listen, I don't want to make this, and I don't want arbitration or mediation. I want us to resolve this. And most brokers would probably agree it's better that we resolve it than having to take it somewhere else. It's always easier on everybody to just get it resolved. Sometimes I've even given up commissions just to get it resolved. I don't want this to be prolonged. Let's just work this out together. So it's always better to go to your broker and have the broker or manager contact the other broker and try to resolve it. All right. Paragraph 3, dual agency. Obviously, if you're a dual agent, you represent both parties. You're a dual agent if the licensee is a dual agent, if the licensee or that salesperson represents both the buyer and the seller or the landlord tenant in the same transaction. The broker is a dual agent if both the buyer's agent and the seller's agent obviously are in the same company. So the brokerage becomes a dual agent. If you're a dual agent, you have to disclose it. You have to have written consent from both parties. You can never act as a dual agent without written consent from both parties. All right. Some states, of course, don't allow dual agency. PA does. Just make sure you have written consent so that they understand. And here, paragraph 3, it says buyer agrees that broker and the broker's licensee stated above may also represent the seller of the property buyer may buy. A broker is a dual agent when that broker represents both the buyer and the seller in the same transaction. A licensee, the salesperson, is a dual agent when that salesperson or licensee represents a buyer and a seller in the same transaction. Or you just have to make sure that the licensing law and the rules and regulations of the Real Estate Commission requires that we, as salespeople, licensees, get written consent from both parties when we are a dual agent. Number 4, your company may or may not practice dual designated agency. If they do, then you check that box. Only your company, only you will have to talk to your broker or manager to find out if you practice designated agency. If you do not, then you would just check the box. If you do, then you just need to explain to them what that is. And basically, designated agency. If a broker designates one licensee to represent the interests of the buyer, and then that broker designates another agent to represent the exclusive interests of the other, to the seller, then the broker is a dual agent in that situation. The agents, they have no relationship. They're not dual agents. In a designated agency office, only the broker would be the dual agent, because the salespeople, the buyer's agent, the seller's agent, should not be communicated. No one knows anything about those files other than the agent for the buyer and the broker, and the agent for the seller and the broker. No one else in that office would be dual agents, because no one has any information about either of those clients. Only one who would know would be the broker. All right. Number 5, broker services to others. Broker may not take action that is inconsistent with the broker's interest. Broker may provide services to a seller for which the broker may accept a fee. Go further down, it says providing such services is not in itself a breach of the broker's fiduciary duty to the buyer. Even though you represent the buyer and you have a buyer agency, an exclusive buyer agency with that buyer, you can still provide services to that seller. They're not your client. Maybe they ask you to order UNO and you charge them a fee. Of course, you have to disclose in a fee that seller is paying you. But you're just saying, and one thing that I can tell you, the many times I've heard buyers say this: if I'm a buyer's agent and I'm showing you a property, let me ask you all. You have a buyer, you have a client, you have a buyer client, you show them a property. You have another buyer client, they're interested in the same property. Can you show that property to 2 different buyers without it being a conflict, or you breaching the fiduciary responsibility to your first buyer, maybe?
You can do that.
Yes.
Absolutely. But there are some buyers who don't believe you can do that. I've had buyers say, well, wait a minute, you're going to show that property to another buyer? And I said, yes, I have another client who's interested in that property. Well, I don't think you should do that. I said, well, why not? Because I'm your buyer. I'm your client, and you show it to me, and I'm interested in it. I don't want you to show it to someone else. There are some buyers who believe that. That's why it says here in the contract that 5B, it says a broker licensee may show the same properties to other buyers and may present those buyers in attempts to purchase the same property that the buyer wishes to purchase. Buyer does not breach a duty to the buyer by showing a property buyer is interested in to other prospective buyers. This is not a conflict of interest. Some buyers actually believe it is. It is not. And you should explain that you're not basically the only client. I may show that same property. I've shown the same property to, I think one time it was like 5 different buyers, and I wrote up 3 contracts with 3 different people. Yes, you can do it. C, if there is a conflict, then you have to disclose it. Anytime there's a conflict and you can't put the interest of your buyer above your interest, the financial otherwise, you have to disclose it. All right. If you believe there's a conflict, anytime you think that your interest, that I can't put, because when you have a contract, this employment contract, the buyer's interest comes here. No one else's interest can come close to that. You have a fiduciary duty to this buyer, which means you have a duty of loyalty. You have other duties. What was that? Oh, I'm sorry. I thought I was going to say that. So look at 5C. It says it is a conflict of interest when the broker or the licensee has a financial interest, a financial or personal interest in the property and cannot put the buyer's interest before any other. If the broker or any of the broker's licensees has a conflict of interest, the broker will notify the buyer in a timely manner. You should, and if you believe, and here's I just believe if you think it may be a conflict, it may or may not, I would still disclose it. I always believe over disclosure is more, I would over disclose as opposed to under disclose. If I even think it might be an issue, I'm going to disclose it. That way you can't act, I never have an issue. The entire contract, paragraph C, it says this contract is the entire agreement between the buyer and the broker and the buyer. Any verbal or written agreements that were made before are not a part of this contract. All changes to this contract must be in writing and signed by the broker and the buyer. If you're going to make any changes to this contract, there is a change to the buyer agency contract that you should use. It's a change to the buyer agency contract. I think is also in our form. So if you want to make any changes, you should use that. You can use an addendum, but there is a form created for that called the change to the buyer agency contract.
Right.
Hey,
I have a question.
Mary's got a question.
Hi, Mary.
Hey,
Yes.
hi. Is it a conflict of interest when you're writing, and you said you did this, like, and I've done it too, but writing, multiple offers on the same property for, a few different buyers, that feels like messy to me, because it's like, I don't know. Do you know what I mean? Like you're
I know
doing
what
your own bidding for.
You know what? I don't, and it's funny, Mary, I didn't like the feeling. I didn't. So what I started doing, because I agree with you, what I started doing when I had a buyer who wanted to put in an offer on something I already put in, I would give it to another agent. Say, I want you to work with another agent. I didn't like it, but it's not a conflict. Buyer agency contract tells us. Now, the one thing I will say, I would tell them that I'm writing up a contract. I'm working with another buyer who's also put in an offer. Clearly, I'm not telling you what the offer is, but I do tell my clients, hey, I've written up 2 other offers myself, which means there are probably other agents out there who write them up. So you better give me your best offers now. Give me your best. But yeah, I don't like the way it feels, but it is okay. But I stopped after I did 3 contracts. Then I for myself decided to always give it to another agent and let them represent that buyer. Because I agree with you, it's not a great feeling. I agree with that. All right, the transfer of this contract.
I have a question, please.
Yes, sir.
Back to paragraph 5, section C. Does that need to be documented in any way?
If there's a conflict, I
Yeah.
think it should, yes.
Okay.
Because
And
you
is
need
there
remember,
a particular form we need to use, or?
No, I mean, you can email. If you think you have a conflict, I would say, let's say I'm representing the seller and now my spouse wants to buy the property. I think that's a conflict. I would, maybe not, but I would disclose it. I probably would. That is a conflict. Yeah, you can email. I don't think there's a particular form. I would call the seller or the buyer, and I would email like, this is a conflict. Now, what do you want to do? Are you okay with this, or do you want to terminate this? You want to find another agent? I always tell people, how do you want to handle? I'm going to let you decide, but I always put everything in writing. I don't do any verbal. We don't do verbal contracts, because if you ever had an issue, you want all this stuff memorialized in writing. Always put it in. I don't like to use text. It's easier for me to just use emails. I would email. And another thing I've always done, if I have a difficult buyer or seller, I put everything in an email. Even after we talk, I just send a quick email. Hey, just to recap our conversation. Because I've had buyers or sellers, sometimes they're not as truthful, and they say they didn't say things. So if I'm at work with difficult clients, I'm definitely going to memorialize it in writing. And just in my practice, as a practice. All right, the contract. Number 7, the transfer of this contract. The buyer agrees that the broker can transfer this contract to another broker when the broker stops doing business. broker forms a new real estate business or the broker joins his business with another. Or B, 7B, the broker will notify the buyer immediately in writing if the broker transfers this contract to another broker. The buyer will follow all requirements of this contract with the new broker. So if you are, for whatever reason, you want to transfer for these reasons, if you have to transfer the contract's still good, the buyer still must adhere to whatever the terms of this contract. Confidentiality is an important one in our business. How long does confidentiality last? When you have a buyer or seller, how long does, everything they tell you should basically be confidential. How long does it last? Does it end after they purchase the property?
Forever.
Forever. What you learn about a client, it is confidential forever. Never discuss the personal, confidential business or private business of any of your clients with your friends or family. It lasts forever. If you had a seller and you couldn't sell the property because it has all these structural issues, do not disclose that to someone as you're driving by the house and say, hey, you see that house? I couldn't sell it because it's got all kinds of structural issues. And by the way, the owner was a drunk. Don't disclose any information you know about your clients, confidentiality. And obviously, there are some situations you may, if you had a court order, if you had to pretend your reputation, if you were being sued or something, but you don't talk about your clients. And if you do talk about them, don't use names, don't use addresses. When I talk about some of my past clients in my classes, I always change the location of the property. I change the gender. I change everything, so you'll never know what I'm talking about. But the facts are the same. But I may be a house in Center City, but I now is a house in Northern Liberties. It was a couple. Now it was a single man. As always, the person may have grown up in Philadelphia, but this person just relocated to Philadelphia. This person was a lawyer, but this person is a teacher. I will just change the facts, so you'll never know who I'm talking about. I mean, I changed those facts, but so no one, whatever you learn about your client should just be confidential. Paragraph 18, it says, unless permitted by buyer or required by law, the broker will not knowingly reveal or use any confidential information to the buyer. Buyer understands that seller or seller's representatives might not treat the existence, terms, or conditions or any offer as confidential. This is important to me, unless there's a confidentiality agreement between the buyer and the broker. You have a confidentiality. You cannot disclose any private discussions or information about your client, the buyer, but you need to let the buyer know that the seller can disclose whatever they want about the contract they received. They can say John Smith brought an offer, wanted to offer me $300,000 on my property. John Smith, the confidentiality agreement, if you want your information to be confidential, if you're someone who's buying property, and I've had clients in the past who did not want their identity revealed, a couple of times I did have the seller sign confidentiality agreements because that buyer did not want the seller to repeat anything about this sale, because there was somebody known, and they didn't want anybody to know that they're purchasing this property. So a couple of times in my career, I've had to do it, but you remind sellers that, hey, you can tell your buyer, I'm not going to reveal any confidential information that you give me. But that doesn't apply to the seller, all right, unless there is a confidentiality agreement. And I bet you most sellers won't sign it, all right? Any questions or comments? Expertise of the real estate agents, paragraph 9. Pennsylvania real estate agents are required to be licensed by the Commonwealth of Pennsylvania and are obligated to disclose adverse factors about a property that are reasonably apparent to someone with expertise in the market of real estate. Just keep in mind that real estate, we are real estate professionals. We should be experts in real estate. We're not experts. We're not lawyers. We're not accountants. We're not inspectors. Stay in your lane. If they need a professional, get a professional. Stay in your lane. If you're in the basement and the person says, is this mold on the wall? And you say, no, that just looks like dirt. No, you're outside your scope of area expertise. Get a professional. Don't answer questions that you don't know the answer to. hire professionals. All right, just stay in your lane. You're an expert in real estate. You're not an expert in construction or whatever else. All right, unless you are, that's something different. If you are a lawyer, then that's different. But if you're not, don't play one. All right. Number 10, deposits. The broker will keep, as we know, all deposit monies that the broker, the licensee receives in an escrow account as required by the real estate licensing laws and the regulations of the Pennsylvania Real Estate Commission until that sale is completed or an agreement of sale is terminated. We know that brokers must put earnest money deposits, security deposits, and escrow account within 24 hours, by the end of the next business day after they receive it. Brokers must put earnest money deposits into an escrow account by the end of the next business day after receipt. So you can tell the broker. Now, if you are representing a buyer and you're turning over a commission, turning over an earnest money deposit check to the listing agent, then you should use the deposit, which should be in there, deposit money notice. Deposit, anytime you are transferring one of your client's monies to another company, you must tell that buyer, that client, where his or her money will be, who's holding it. So if I'm representing the buyer and Compass is the selling agent, I have to say to my client that deposit money notice would do that your money, your check will be turned over. First of all, make it payable to Compass, and it will be turned over to Compass, and they're the ones that be holding it in their escrow escrow account. All right. And he also says that the buyer and the seller may name a non-licensee as an escrow holder. In which case, now, who's a non-licensee as an escrow holder? An attorney, a title company. Be careful and I see it happening more and more, brokers don't want to hold escrow. If you're not going to hold the escrow, if an attorney's holding it or title company, they're not bound by the laws of the Real Estate License Registration Act or the rules and regulations of the Pennsylvania Real Estate Commission. So we as brokers know what they can and cannot do with escrow funds. If you have a title company hold it or an attorney hold it, make sure you get an escrow agreement and you read it and understand. Because what happens if there's an escrow agreement and the title companies hold it, and after 7 days they just automatically give the money back to the buyer, or they decide who gets it and they turn the money over to the seller? I don't know. I don't want anyone. I personally don't want attorneys and title companies holding escrow. I prefer to have it held by a broker personally, because I know when, how, and when that broker can release that money. I don't know what the escrow agreement says for this title company or that title company, because they're probably all different. So just be mindful that when you have someone other than a real estate broker holding escrow, make sure you at least get the escrow agreement and you know what happens. If you're the buyer's agent and the escrow agreement says that, hey, we get to determine if there's a dispute, we get to determine who gets the escrow. Well, I don't want that. So just be mindful of that. So it says the buyer and seller may name a non-licensee as the escrow holder, in which case the escrow holder will be bound by the terms of the escrow agreement, not by the Real Estate License and Registration Act. All right. But brokers are bound by the Real Estate License and Registration Act and the rules and regulations of the Real Estate Commission, not the escrow company. Not the title company or the attorney. Any questions or comments? B, regardless of who holds that, regardless of their parent entitlement to deposit monies, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to the deposit monies when settlement does not occur. Okay, we all know that. And there's only a problem when there's a problem. This is something I always point out to buyers. I'm turning your check over to this brokerage. If there is any dispute as to who gets this money, if there's a breach or an alleged breach, then I have nothing to do with it. You can't include me in the lawsuit, because if you do, then you have to pay my attorney's fees. I have nothing to do with it. And the broker holding that deposit can only release your money. Look at these. This is really important. Look at B, 1, 2, 3, and 4. It says that, well, I'm trying to get 1. If there is no dispute, if an agreement to sell is terminated prior to settlement and there's no dispute over entitlement to deposit money, then the broker can release it back to the buyer. How do you know there's no dispute? Because they signed an agreement to sell, release, and distribution of deposit money. That's another form that you have in the library. So number 1, there is no dispute. I had a home inspection done. It had too many issues. I don't want to buy this property. I did it within the 10 days. If I left it that way in the contract, I tell the buyer I want to be released. I'm obviously entitled to my earnest money deposit. I'm going to send over a release. Seller should sign it. The broker can release that money back to the buyer. Number 2, if there was a dispute, but it's been resolved, look at number 2. If after the broker has received deposit monies, the broker receives a written agreement that is signed by both the buyer and the seller, directing the broker how to distribute some or all the deposit money. Well, 2, there was a dispute, but the buyer and seller decided how they're going to resolve it. And the broker may not be involved. Buyer and seller decide how they're going to resolve it. And we're going to send you this release saying that, hey, we decided that we're going to split the money. The seller's going to get half, the buyer's going to have. Here is our agreement signed by both parties. Then and only then can that broker write that check. The third one, according to the terms of a final court order of court. Obviously, if a court says that this deposit money should be returned to the buyer or it should be given to the seller, then that broker is obligated to do that. Now, it says a final court order, not if all the appeals have been exhausted. And number 4, according to the terms of a prior written agreement between the buyer and the seller, directs a broker how to distribute the deposit monies if there's a dispute between the parties that is not resolved. And where is that prior written agreement? It can be found in paragraph 26C of your agreement of sale. Where, let me see if I have one. Remember, in the agreement of sale, let's see, agreement, paragraph 26C. Just make a note that that's your prior written agreement. And your if you look at paragraph 26C in the agreement of sale, it says, or it reads, buyer and the seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved as a blank, and it's 180 days. If it's left blank, I would probably put 30 days or so, but I'm just going to put 30 and read it again. Buyer and seller agree that there is a dispute over the entitlement to deposit monies that is unresolved 30 days after the settlement or following termination of the agreement, whichever is early. Then the broker holding deposit monies will, within 30 days of receipt of that dispute of the buyer's written request, distribute the deposit monies to the buyer unless the broker is in receipt of verifiable written notice that the dispute is a subject of litigation or mediation. In other words, when you're doing an agreement of sale, pay close attention to paragraph 26C. Make sure you know if you leave it blank, it's 180 days. That's a half a year. You put 30 days. Let's say the buyer clearly breached the contract, but the seller has not initiated litigation or mediation. And it's been, let's say now it's 60 days, but you put 30 days in that slot. So now the buyer can send a letter to the broker for that seller saying, please return my earnest money deposit. This is that prior written agreement. And that once that broker receives that written request from that buyer, in this example, then that broker has 30 days to return that earnest money deposit to that buyer. Even if during that period, the seller goes out and initiates litigation, it's not, but they still would have to return the money. They would have to initiate litigation or mediation before they receive the letter, not after. Now, it also goes on at the end of the paragraph to say that once the distribution is made, let me read it. it says, the last paragraph, it says, well, buyer and seller agree that the distribution of deposit money is based upon the passage of time, does not legally determine entitlement deposit monies, and that the parties maintain a legal rights to pursue litigation even after a distribution is made. So the seller could still sue, but now the buyer is holding his or her money and not the broker. So they may still have to turn it over, but just keep in mind that they have 30 days. If you put 30 days in that contract, or 60 days, whatever, and there's a legitimate dispute and the seller has not done anything, the buyer can still have his or her earnest money deposit returned. All right. Any questions or comments? Are you all getting anything? Are you on board, or am I losing people? Huh? You learning
So
anything?
Trent, excuse me, I
Yeah.
just wanted to add here. So if there is a dispute and so either party is not willing to give up that disputed deposit monies, then you have to give me a call, because then you have to file for mediation, and then the buyer and seller will have to mediate the dispute over the deposit monies, and it is their agreement that lets that broker know who in fact will receive that deposit money. All right, and that agreement is binding in court. So if they were to go to court first, the judge is going to take a look at that agreement of sale, and he or she is going to refer them back to us because of that mediation clause.
Tom, you had a question or comment?
I do. Hi, Cheryl. I've actually gone through this where we had a property. It was a new construction, like 3-unit condo on Fitzwater. Turned out the seller didn't have a certificate of occupancy. We didn't close, and we found out he actually lost his license because of that. We went to mediation. He wouldn't agree to give back my client's deposit, which was like $19,000. First, he said he wanted to keep 5. Then he's like, I want to keep the whole thing. But you're saying after 180 days pass, she should get her deposit back regardless, and then they could do subsequent court action.
If you leave it blank and the buyer sends a letter to the broker for the seller, the broker holding the escrow monies, then the broker has to release it back to that buyer if that seller, that broker, did not receive anything about litigation or mediation from that seller. If they didn't receive anything, they didn't initiate it, then they within 30 days have to return the money. But then, of course, later on, that buyer is entitled, the seller is entitled to go back and sue even after distribution is made. But yes, the broker would have to return the money if the seller.
We did mediation. Cheryl helped us with that, but they didn't come to any kind of agreement. So is that still the same case where they should get the deposit?
Well, I don't know about the meet. Cheryl?
Yeah, so if they went to mediation and there was no agreement, then they have to take that to the Court of Common Pleas at that point.
But what about the 180 deposit refund? You're
Yeah,
saying
so I mean, like if they were like within that time frame and mediation was conducted and the parties has not come to an agreement, then it has to go to court.
And the broker just holds it indefinitely, you're saying?
Yeah, until a decision is made as to who should get the deposit monies. If the buyer and seller cannot come to an agreement on their own.
So she needs to go to
mediation was
court.
conducted, so they have fulfilled that mediation clause in the agreement of sale, then you move on to court.
And the broker
They
just
should
holds the
receive
deposit.
at that mediation conference, something that says, hey, mediation was held, Friday, December the 15th. However, there was no agreement between the buyer and seller. And so that would be their proof to show a judge, and then the judge will make that decision as to who gets the deposit monies from there.
So she needs to go to court, basically. That's the only way to get it back.
Yes.
Right.
Yes.
All right, let's look at C. 10C says the buyer agrees that the buyer names broker or the broker's licensees in litigation regarding deposit monies, the attorney's fees, and the cost of the broker and licensee will be paid by the buyer. So make sure buyers know this, that if there is a dispute, I'm not holding it. Don't include me in this lawsuit, because if you do, you have to pay my attorney's fees. because the broker is doing whatever it was doing, is holding the money according to the licensing laws in this state. So if the broker is not releasing money because you gave it to me, you may think that I should get it back. I can't. Don't include me in litigation because you will be responsible for my legal costs. All right, paragraph 11,
Hey, Trent,
civil rights
Trent,
law.
Trent,
Yes,
to
sir.
interrupt, Dave Lombardo had his hand up a moment ago.
Yes,
Is there
Dave.
a question there?
Oh, it was just in regards to what Tom was asking about the 180 days. I was gonna say that once that seller sends that, you know, the legitimate notice that he wants to deposit, the 180-day thing is over. Like, it doesn't matter. He sent it. Like, you were asking, oh, after 180 days, can he just, even though they're in litigation, can the money come back? No. In my opinion, no, because he sent it. If he didn't do any communication, like saying, hey, we want the money, here's an attorney saying it, then the 180 days is in effect, or whatever day you put in there.
And it's
I think
not
that's
just
what
an
Tom was
attorney
asking.
saying, it's not just an attorney saying it. It has to be they would have to file something. You can't just get a letter from an attorney saying.
Oh, right. That'd be
that,
real.
Right. You have to show
be the
that
seller calling up saying, don't do
Right.
anything with that, Mr. Other broker, or the, you
Right.
know, it has to be
Right.
legitimate. But once that's delivered, the 180-day thing's over now. It's got to
I
be
agree.
filled in.
I agree.
That's what
I
he was
agree.
asking.
I agree with that. All right. Civil rights laws, paragraph 11. We all know with real estate professionals, we should never be involved in discrimination of any sort, but this lays out, says federal and state laws make it illegal for a seller, a broker, or anyone to use race, color. These are protected classes, or 7 protected classes on the federal level. Pennsylvania has a few additional ones like age and religious creed, ancestry, but the race, and what race are they talking about here? What race? You can't discriminate against race. What race? Anybody? Nobody?
African American.
No. What race? All races.
All races.
Most people give me that answer. They say African Americans. That's why I asked the question. Doesn't matter. You can't say, I'm not selling
just the
this
human
property
race.
to a person who is white. That is a violation of state federal law. It doesn't matter race. If you're human, you fall into a race. So all races. What about color? Same thing. Doesn't matter what color you are. You discriminate against a person based on the color of their skin, you violate federal and state laws. What about religion? What religion are they talking about? All religions or no religion. I may be agnostic. I don't believe in anything. You say, I'm not going to sell to anyone who doesn't believe in anything. Then you violate federal and state laws. So race or any race, all races, color, all races, religion, all religions or no religion. A religious creed is basically like an expression. Maybe if I'm Jewish and I wear a yarmulke and you discriminate against me because I have a yarmulke, you can't. That would fall under like religious creed. Those are not only your beliefs but your observances. Or I'm Muslim and I have a certain beard. You can't say cut your beard because that would be a violation of the Federal Fair Housing Act and the Pennsylvania Human Relations Act. But race, color, religion, or religious creed, sex. What falls under sex? All genders, sexual orientation, gender identity, and sexual harassment also falls under, is like a subsection of sex. Use or handling of training of support animals as reasons for refusing to sell, show, or rent properties, loan money, set deposits as a reason for any decision related to the sale of property. Here's what I always say: if you treat everybody the same, you never have to figure out whether you violate the Federal Fair Housing Act or the Pennsylvania Human Relations Act, because you have policies that I always like to say, what you do for one, you do for all. Then you never have a problem. What you do for one, you do for all. If I make you put down, fill out an application, I make everyone fill out the same application. Use the same policies. If I won't show you a property without a pre-approval, then don't show anybody a property without a pre-approval. Because then someone may say, hey, I had to get a pre-approval because of my gender, or because of my sexual orientation, or because of my religion, or because I didn't see, I skipped a couple of them. I'm going to say, where's familiar status? Disability, I'll go back. Disability, that's any mental or physical disability. Familiar status, families with children under 18 or pregnant woman. So if you discriminate against someone because they have children under 18 or the woman is pregnant, or for families adopting kids, you would be violating state and federal law. Don't take contracts, don't take listing contracts where the client is telling you to discriminate against someone based on being a member of a protected class.
And
Any
Trent, that's
questions?
also in the Code of Ethics, Article 10.
Absolutely. Code of Ethics, Article 10. We should be ambassadors. We should not be engaging in conduct that is really reprehensible. If you've been in this business for any number of years, you've had people say to you, don't sell. I've heard don't sell to Muslims, don't sell to whites, don't sell, and whites, Asians say don't sell to blacks, Latinos, Asians. I've heard don't sell to families with children or don't rent to families with children. If you've been in this business a while, you have heard it. And you have to educate the consumer or the client and let them know that I can't take a listing where illegal discrimination is concerned, and I won't take it. Now, I've had to educate people, like families with children, for instance, is one of those where everybody thinks it's okay to discriminate against families with children. That's one that everybody thinks is okay. Oh, Trent, I don't want children on the second floor because of my tenant on the first floor is an older man and he's a little sickly. So can you not put children on it? Well, I said, no, I can't, because that would be a violation of the Pennsylvania Human Relations Act and the Federal Fair Housing Act. If the family with children, if they qualify, then I put them up there. Otherwise, I am not taking this listing. You want to do it yourself, you can put whoever else you want up there, as long as it's not based on race. Because there's never an exception to race. There's some exceptions to some of these others. Race is never an exception. Any questions or comments? Number 12, notice regarding convicted sex offenders. The Pennsylvania General Assembly has passed legislation providing for community notification of certain convicted sex offenders. Buyers are encouraged to contact the police department or the Pennsylvania State Police for information regarding the presence of sex offenders near a particular property, or to check the information on the Pennsylvania State website. Give this to your clients. Whatever you do, do not check for them. Tell them they can go to www.pameganslaw.state.pa.us. Don't ever check for your client to see if there is a convicted sex offender in the neighborhood. Because if you happen to miss someone who's living on that block and they attack their children, I'm assuming that person's going to include you in the lawsuit. If someone's asking you if I have young children, I don't want to live around sex offender, you say, you can call the state police, you can go to the website, and because sex offenders have to register their addresses, but don't you ever get involved in that. Don't you ever get involved. You give them the information, you let them look themselves. Any questions or comments? Paragraph 13, buyer inspections. Basically, this paragraph just says unless buyer and seller agree otherwise, the real estate is being sold in its present condition. It is the buyer's responsibility to determine whether the condition of the property is satisfactory. Buyers advised to carry out an inspection. So even though, tell buyers never to rely on what they see in the MLS, what the seller tells them. Whatever information they get, they should verify it. Because seller may say to you, the AC unit works fine. Well, maybe it worked fine when it was on last summer, but this summer is not working. It's not working that fine. Or maybe they thought fine because it worked half the week and didn't work the other half of the week. You need to have buyers verify everything for him or herself. Don't take the word of anyone. I don't care what's on the seller's disclosure. It may not be correct. If you're concerned about the roof, have somebody go up there and take a look at the roof. Even though the seller says, the roof has never leaked and it's not an issue, have them verify things for themselves. That last paragraph, that last sentence there in B, look at B, 13B. It says, buyers advise that information regarding properties considered for purchase by buyer has been provided by seller or seller's broker. last sentence says, unless otherwise noted, the broker has not verified the accuracy of this information, and the buyer is advised to investigate its accuracy. So you're telling buyers, I'm only giving you that information that the seller or the seller's agent provided to me. If you want to make sure this information is correct, then we need to hire someone to do it, to verify it. But don't just take, because if you're just taking the information given by the seller, it may or may not be correct. Any questions, comments? Recording of the property, paragraph 14, any person who intentionally intercepts oral communications by electronic or other means without the consent of all parties is guilty of a felony under Pennsylvania law. Buyers should not make recordings on the property to capture the oral statements of other persons without having the full consent of all persons who are party to the communication. Buyers should be aware that a seller's property may contain smart home technology devices, and we're seeing this more and more, which may record or allow for remote monitoring of the seller's property, including broadcasting or recording video and audio. Buyers should be aware that any discussions, including discussions of negotiation strategies held on the property, may not be confidential. They should be, but they may not. I never have negotiations in a house ever. I have never done that. I don't know who's listening. Even before all these smart technologies, I say, let's go out the house. I don't know what is going on in someone else's house. And I know I've been in houses before where they could hear us, because once we were in the basement looking at a house with all these smart technologies, the agent actually came on because we had a question about something and answered the question. He said, oh, by the way, I'm listening to y'all. And I said, you listen to us, and answered the question that we had a concern about, which freaked us all out. So then I said, say nothing else. Say nothing else. Any questions or comments about this? Any comments about anything? How we doing?
Good. Thank you, Trent.
Good.
All right, look at number 15, recovery fund. That has to be, and this disclosure is required by both the Real Estate License Registration Act and the rules and regulations of the Real Estate Commission. The Pennsylvania has a real estate recovery fund to repay any person who has received the final court judgment against a real estate licensee because of fraud, misrepresentation, or deceit in a real estate transaction. If a licensee, if you defraud one of your clients, and that client goes to civil court and gets a judgment, a final judgment against you, and tries to collect on that judgment, but cannot, then within 1 year, that client can go to the real estate recovery fund and recover the money. But the maximum for one claim is $20,000. No one can get more than 20, and it's $100,000 per licensee. So 5 different people can come with a claim of a civil judgment, a final civil judgment of $20,000. What happens when the real estate recovery fund pays any monies out on your behalf? Your license is suspended, and before you can get it back, you have to pay all the money back plus 10% interest. So hopefully that will never happen to any one of us. But that's why we should be careful in the way we conduct business, so that we never.
Repeat that one more time, please. Could you repeat that about paying the money out and how much is paid, a maximum, one more time?
If you once, let's say, I'll give you an example. Let's say not you, an agent defrauded a client. And they went to civil court, got a judgment, a final judgment against that client, that agent, for let's say $25,000. They first have to try to collect on that fund, on that judgment against that agent. Before they can come to the real estate recovery fund, they have to try to collect, maybe garnish wages, et cetera, et cetera. Let's say and they have to come to the real estate recovery fund within 1 year. They bring this judgment, this final judgment of $25,000 to the recovery fund, and says, I tried to collect money from this agent who defrauded me. I could not. Now I've come to the real estate recovery fund to collect. The maximum they can collect from one agent is $20,000. So they may have a final judgment for $25,000. The real estate recovery fund will give them the $20,000. that 20 per claim. There's 20,000 the maximum per claim. There's 100,000 per licensee. In other words, once they pay out 100,000 on your behalf, then that's the maximum they can pay. They can't pay out any more. Your license is automatically suspended anytime the real estate recovery fund pays out any monies on your behalf. And in order for you to get your license back, you have to repay all the monies that the real estate recovery fund paid out, plus an interest of 10% on that money. You got it? Is that?
Yes, yes, thank you.
You're welcome. Any other questions or comments? All right, look at paragraph 16. There's special clauses. If you have any special clauses or any other terms and conditions that you and the buyer may agree to, then you should state it here, whatever that may be. Just like Mary said, she may. This is probably Mary. This is where you put that within. They can terminate within, what is it, 24, 48 hours, et cetera, et cetera. Is this where you put that in the buyer agency contract?
No, I put it up at the very beginning where you have the start date, and then
So,
I like
okay.
asterisk where the end date is, and then I type
Okay.
in
You just said-
asterisk and I
okay.
write my line out. Yeah.
Okay. You could just put it here if you want, but the way Mary does it is fine too. Further down, it says buyer has read and received a consumer notice. We always have to have a consumer notice. That's the first thing you have to give to a customer, a client, anyone. Anytime you have a substantive conversation about real estate, you must give them a consumer notice. And if you are on the phone and you do read the verbal consumer notice, the first meeting with that customer, consumer, you then have to give them the written version of the consumer notice. All right. Buyer has read the entire contract before signing. If the buyer is getting mortgage financing, buyer will promptly deliver to broker a copy of all loan estimates and closing disclosures upon receipt. Why is this? Because the lender is not allowed to give us, the licensees, the buyers, the loan estimate or closing disclosure. They go to the client. So you need to remind buyers, as soon as you get this LE, this loan estimate, or this CD, this closing disclosure, forward it over to me ASAP. All right. So you need to remind them that, because the lender is not sending it to you, they're sending it to the borrower. All right. The next paragraph, or return of this contract and any addendum or amendments include and return by electronic transmission bearing the signatures of all parties constitutes acceptance by the parties. In other words, if you fax it, you sign it and fax it back, that's perfectly fine. We still have a full-fledged contract. It doesn't have to be, you don't have to have wet signatures. You can sign it and fax it or e-fax it or there's a million different ways you can now sign contracts and get them back. This contract may be executed in one or more counterparts, each of which should be deemed to be an original, and which counterparts together should constitute one and the same agreement of the parties. In other words, I could have two buyers, one signs it, one's here. Well, let's say one's here and one's in California. I can send the same document to both parties, and they both can sign it and send it to me, and I can put it together, and it becomes one contract. They don't actually have to sign the same contract. It must be the exact same contract that they both sign. That's a counter signature. So if I have three people in three different places, I can just send them the contracts, they sign it, and I don't have to have one sign and send it to someone else. Obviously, if you're DocuSigning it, it's easy to do that, but you can just have people sign it and you can put it together. And a contract that's counter signed is fine. Notice before signing, the buyer has legal questions. Buyer is advised to consult a Pennsylvania real estate attorney. I've heard agents say before, you don't need a lawyer. Don't ever tell someone they don't need a lawyer. If they want a lawyer, do not ever discourage them from getting one. If they feel like they want an attorney to look over this or to consult with them, you say, fine, go do it. Don't ever say to someone, and I've heard it many times in my career, you don't need a lawyer. Don't ever tell anyone. Don't discourage anyone from needing a lawyer. If they feel comfortable having a lawyer look over this, then you say, by all means, take it to the lawyer, or I'll email it to the lawyer, whatever, because just never do that. Buyer, then of course, then the buyer signing dated, you're going to sign on the broker, the company, again, put the name of the company as it is on your license, not, if it's Remax, what I say, Malvern, I don't know if there is one, but it would be Remax Malvern, not just Remax. All right, and then you accept it on behalf of the broker, so your signature goes there, and then you will date it. Any questions or comments? We got a little bit more time. Any questions or comments? Any
Question.
Yes.
It's me again. What happens if buyer refuses to sign contract?
Then you can't be paid. That's the long and short of it, because you cannot. The licensing law says that you can represent a buyer without a buyer agency contract, but it also says that you can't collect a fee without one. So if a buyer won't sign it, then I would work with them, because you're just working as a volunteer, basically what you are. Because your broker should not, if you represent a buyer and the buyer agency contract is not in your file, then thank you, Mary. Then you're not entitled to a commission. Your broker should not give you a commission without a buyer agency contract. So you really need to have a buyer sign it. Now, I will say this, Drew, what I've done is just make this contract. Let's say I have someone who's coming in tomorrow. I'm just showing them property on Saturday. I just make it for one day. And I never have a problem getting people to sign. I said, listen, we're going out tomorrow. So if you buy any property that I show you tomorrow, then I'm the agent. But Sunday, this is going to end at 11:59 on Saturday. So as of Sunday, this contract is no good. So if you go to another agent on Sunday and they show you a different property that you buy, fine. But if you buy the property that I showed you, I'm entitled to a commission. So sometimes it's easier just to make it a shorter, just make it a weekend, make it a week. I mean, if they're not comfortable, say, hey, why don't we make it for 5 days? And if you're comfortable with me and you want to continue to work with me, then we'll make it longer. What do you think of that, Drew?
Yeah, I mean, I agree. The term doesn't, the length of the term does not matter. It could be for a day, it could be for just that afternoon, for that matter. As long as you have something written, I get it. But something has come across my office where, somebody refused to sign a contract, and I said the same thing.
Not even even for a day.
How do you,
Trent.
no, they did.
Sorry to interrupt. Can you hear me, Trent?
Yes.
Okay, so there was a woman going around a couple of years ago that was doing that, didn't want to sign contracts, running around with a bunch of agents. And those of us that encountered her were familiar with her name. So what I had worked with her and put in some time. So what I did with dealing with her was I told her that I wasn't going to let her in the property unless she signed the business relationship. Like you're not getting access. And what I did on the business relationship, because she was so shady, was I put each address that I showed her on there. So whenever you wanted to buy these within this time frame, I'm going to get paid. So, because if you do a day, you don't have proof what you show, what you didn't show.
Well, what
so
matters?
I had the addresses on there.
I like that, Eve, but if you're using an exclusive right to sell, it doesn't matter what you showed or didn't show. If they bought a property that day, then you're entitled to commission.
Okay.
But Drew, I want to go back. Drew, so you're saying that somebody just outright didn't want to sign it even for a day, an hour, a property. They just didn't want to sign a buyer agency contract.
Correct.
Well, then I wouldn't work with them.
Agreed.
I like what Eve says, but I wouldn't work with somebody who's saying, because I would say to a buyer, I cannot, by Pennsylvania law, I'm not entitled to be paid either from you or from the listing agent if I don't have a contract with you. So if they can, so yeah, if they refuse to sign it, then I would probably walk away and just and have them fine. Tell them maybe you should go to another agent because
Well,
I'm not going to work with somebody.
yeah,
What was
isn't it also with the contract that, I mean, once you've signed and developed that relationship, a binding relationship, that, you know, it gives you the powers to negotiate for them. It gives you,
Right.
stability to go and, research the houses and, do work for them, basically, is what you're doing at that point.
Exactly.
You know,
That's why I
now
call
you've
it
got that
employment.
relationship started.
Exactly. That's why I call these employment contracts, because you're being employed by the buyer or employed by the seller with the listing contract. And I like what Eve says. I mean, if you have clients that you don't trust, I like that. Put down the properties that you showed in the contract. Don't let them in that house unless I like that. We're meeting at the house. Oh, by the way, before I get the key out of the key lockbox, I need you to sign this buyer agency. And they say, oh, no, I don't want to sign it. So you get back in your car and you drive off. I could like that.
Excuse
Because
me.
I bet, what was that, Donna?
I want to ask you, what's your opinion or thoughts on the MLS contracts that we have to sign with Bright regarding
mean?
that? Because we have to sign a contract that we have to share the commission that is
Well, it didn't
noted.
say share. It says that didn't they change it so that you don't have to share? You could actually put 0. The listing agent can say, I'm
You
not
can,
sharing.
but the amount that, I'm saying the amount that you put on there, the amount that you do put on there, you're
Oh, the amount.
required.
Okay. Whatever you put on, you have to share. You cannot change
That's
it.
correct.
You can negotiate it before. Once you get an offer, an agreement sale in your hand, and the MLS said that you're giving 2%, then you have to give 2%. You can't make a contract contingent upon you getting more money.
Right, and that's regardless of whether or not you have a buyer agency agreement.
Right, right. But whatever's in MLS, you have to pay. Whatever you offered as a compensation to the buyer broker, then you're bound by that. You can't change it.
And I wanted to interject a couple times and I just held off until the end. I wanted to just say, that 180 days, I am one of the people that fought for that to be changed. And it did get changed. It was 360 originally.
Yeah, it was
From
360.
180 now it's in there with a line that you can change it and adjust it depending upon who you're representing.
Right.
I advise you to think about that and speak with your brokers. I am a broker and I advise my agents accordingly. And the other thing, going back to, I think it was Marie or Mary with the conflict for the buyer and going to an arbitration. If you think that you may have a problem or there may be a problem down the line, there is an arbitration questionnaire that you should look at and you should know ahead of time and be following those rules to make sure that you're on the right side. So that just kind of keeps everything in line for what you should be doing with a client.
Agree.
And that's within, I think that's with the National Association that you can pull it offline. And I had an agent pull it offline. And the dispute for commission wasn't with, it was with another agency for procuring cause.
Okay.
And because I made him follow that, we did end up getting the commission because the other agency was wrong.
Okay.
So it's a good idea, good rule to follow, just to keep you reminded and mindful of what you're doing.
I agree. I totally agree. Thank you, Donna.
Thank you so much also for your input. There are a couple things that everybody does things a little bit differently, but I always ask the question and tell the agents, ask the question, what if? You mentioned something about what if the deal doesn't go through? Yes, you'll have a lease. I'm not doing a lease for this amount of time. It'll be this amount of time. You have to prepare for what if. I've gotten contracts from other agents and there was a lease involved. I said, you're only allowed 30 days. Everything has to be completed. Don't give me a contract that's half completed.
Exactly. I agree. And I totally agree. And don't always tell agents, and Donna, I agree with you, what's the worst case scenario? Always think, what if there was an issue? Do I have everything in my file that will show that I did everything correct? What if something went wrong? That's that's always been my approach. What happens? And when I have difficult clients, I even put another level in there. I document every conversation.
I've been fortunate enough, my background is I worked for attorneys for many years, so I think differently. So
Right.
yes, that what if is a big question.
I agree.
And then also the discrimination. I recently had somebody knock at my door, and it's a big franchise company doing an open house, neighbors only. I was floored.
They said
Floored.
who? Neighbors?
An open
only?
house, neighbors only.
Really? That's interesting. I've never. Why?
Naivety. I could say a lot of answers, but I won't.
Right. Okay. Okay.
Yeah.
Interesting.
Donna, sometimes agents will go before the official time frame of the open house and knock on neighbors' doors and say, I want to let you know I'm having this open house here today from 2 to 4, but if you'd like to come at 1 o'clock, I'm telling the neighbors they can come sooner. Is that not allowed?
That wasn't the case.
Okay.
That
That
wasn't the
doesn't
case.
sound
But if
like
you're
the
having an
case.
open house, it's open. I mean, if you're giving a courtesy to somebody, but it's an open house.
It should be open to the public. It should, right. You
yeah.
shouldn't tell people they can't. This is only open to single women. No children. I would not have it. I would just, if it's open to the public, allow the public to come. Any other questions or comments?
I have a question again about if you want to have your contract just for that one day to get the buyer to sign it. And then the buyer comes back a week later and says, you know, that house I saw last week, I think I want to buy it. Do you need to have another buyer agency, exclusive buyer agency contract extending the date?
No, because your buyer agency contract says that any properties that they purchase while this contract is in effect, you earn a commission. And if you show them that day, if you had it for the 14th of December and they want to buy a property you showed on 14th of December, why would you need another one? I don't think you would need another one. Would I get another one? I would, but I think that they showed you the property. You bought a property while it was under while your contract was in effect. I believe you're entitled to the commission. But would I get asked them to sign another one? I probably would, just to have it in my file. But I don't think you have to have it.
Okay.
That it? No other questions or comments then? Mike, thank you all then. I hope this was helpful to you all.
Thank
Thanks,
you,
Trent. Good stuff.
It was very helpful.
I appreciate you,
very
Trent.
Good
Thank
stuff,
you.
Trent.
Thank you.
So
All
everybody,
right.
let's give a round of applause to Trent. Thank you so much, Trent.
You're
And also
welcome.
too, thank you to all of our attendees. We had some good input today, good questions.
Really was.
And
I
as
thought
you can tell, right, we've done this webinar many times before, and each time we go around, there's always something new, a new wrinkle, a new situation.
Yeah.
It's ever evolving, and it's not always about a new agent coming in here. We had great input from seasoned grizzled people.
Right.
They
Right,
also had
seasoned.
questions too, right?
Absolutely.
It's always in
As-
motion. Randolph has
Yeah.
his hand up. Randolph, go ahead.
Yeah, it's Rodolph. Thank you very
Oh,
much.
Rudolph.
for,
Sorry, Rudolph.
saying that. Yeah, it's Rodolph.
Rodolph.
It's
Rodolph.
fine. Yes. So yeah, as you speak of a new agent, I am one of those. I'm a new one, and I just want to say this is my second time participating in this class for buyer's agency contracts. I want to have this question that I have for you guys. Like, is there any way that for somebody like me, because this class was such a good class and so important, is there any way if I want to go back? Is there any like post recorded of this class available somewhere?
Yes. So we have a YouTube channel,
Mm-hmm.
and it's at Philly Realtors. That's our handle. And we have a whole library. There's about 100 and I don't know, 30 some videos in there.
Mm-hmm.
And this video will be posted up to there by day's end. I suggest subscribing to the YouTube channel, so that way anytime we post a new video, you know, if you missed the fact that we did a workshop or something like that, you'll get an alert about that video being posted up.
Interesting. Okay, great. You say that's Philly realtors, right?
Yeah, give me one sec. I'll grab the link and
Yeah.
share it in here. If you can just-
Sure, I would appreciate that. Yeah, I'll stay around.
Any other
Yeah.
questions by anyone?
No,
All right, just hold on and I'll get that link into the chat. Again, thank you, everyone. Have a great weekend. This was our last one for the year, so happy holidays.
Yeah.
Be safe. Look out for the other guy. Look out for yourself. And take some time for yourself too, right? So take care. We'll see you soon.